Hey, guys. Welcome to Building This Community.
This is your city business and policy development podcast. We're your hosts,
Luke Patrick
and Andrew Klump. Welcome to this week's episode of Building This Community. Our guest today is Darren Heitner, who is a former sports agent turned intellectual property attorney, former contributor to Forbes, and an adjunct professor at the University of Florida Levin College of Law. Darren, how are you?
I'm doing great. How are you?
Doing well. Glad we could have you on the show today. So I just gave people a little bit of the background, but can you tell us a little bit more about yourself?
Sure. I started my own law firm back in 2014. Prior to that, I had worked at two law firms in South Florida, and currently I'm in Fort Lauderdale, Florida. Really, I was born and raised in South Florida, went to school at University of Florida from 2003 to 2007, earned a political science degree, and then went straight through to law school from 2007 to 2010 and started practicing law immediately thereafter. As you mentioned in the introduction, I'm a former sports agent. I actually started a sports agency as I was going into law school in 2007, built it throughout my 3 years of law school, continued to work on it for roughly a year thereafter while I was at my first law firm, and then decided that I preferred practicing law and put aside that dream of being a sports agent, at least for the time being. And as you mentioned, I am also a teacher, and I taught at Indiana University at Bloomington for 3 years, a sports agency management class that I started from scratch. What's kind of cool is recently, following the NBA draft, two of my former students are actually agents who represented players who were selected in this year's NBA draft. That was a cool moment. And then this past week, even talked to another former student who works at the NFL Players Association. So that's a cool feeling. And currently, I do teach sports law at University of Florida Levin College of Law, where I went to school. So to do that within 10 years of graduating is also a really cool feeling. But my main practice is practicing law. I've been doing that for over 10 years now. And as you mentioned in the intro, I have a pretty strong practice in intellectual property. It's not all that I do, but I've certainly, I believe, created a name for myself in that area.
So, Darren, that transition from sports agent to trademark or IP attorney, that's super interesting to me. Can you explain what drove that transition and what that meant to you?
I can't say that I specifically planned on pivoting from sports agency to being referred to as an intellectual property lawyer. What I intended on doing initially was simply practicing law. And at first, believe it or not, my first year of practice, I was primarily handling insurance defense litigation. And what happened was in my off time, whether it be at the end of the workday or thereafter, I tried to build my own book of business. And one area that fascinated me wasn't actually even trademark, it was copyright law and specifically litigation surrounding copyright. And I don't recall the specifics. I think it was based on my writing, in fact, that I started to gain some clientele who had been sued for copyright infringement. And from there decided, look, I had this background where I took many intellectual property related classes while I was at law school and felt comfortable with the area, saw it as a nice niche area that a lot of people who didn't have that type of background didn't feel comfortable getting into. But initially, when I pivoted from being a sports agent to practicing law, I believed that I could convert a lot of those sports agent competitors into clients. And I've actually done that. I find it interesting that in the intro, you referred to me as an intellectual property attorney. And I personally don't care how I'm branded, but I think more commonly I'm referred to as a sports lawyer, somebody who does a lot of work in the realm of sports. And then I would suppose secondarily as an intellectual property lawyer, where a really interesting niche came about is actually the intersection of the two, where I work with a lot of agents and athletes and other sports businesses and individuals in protecting, enforcing, and litigating their intellectual property rights. And that's an area that I don't think there's not many people who have branded themselves in such a small niche.
Well, and I think to your point, right, that the sports law industry, especially when you're talking to law students or whoever, people don't necessarily think about how broad an industry that actually is. Whether you're doing intellectual property or, there are some people that might set up foundations for athletes, or there's just different ways to intersect with professional athletes in that industry. So can you just kind of maybe give some advice to those looking to break into sports law?
You're absolutely right that there are so many different areas of the law that fit in with working in the sports related business. So what I oftentimes recommend to people is don't focus on necessarily sports law subjects. In fact, when I was in law school from 2007 to 2010, there was a single course that was offered. It wasn't even offered every semester. And it was a seminar course that you could really only get into as a 3L, third year in law school. And it was a sports law course. It was the only one. And it was really taught by an older professor who was teaching out of date precedent. And so I didn't have the sports law curriculum that I think a lot of people covet. And there's not many law schools that really focus on it. There's Tulane, there's Marquette, University of Miami's built in the recent years a pretty robust sports law program. But truly, there's very few law schools that have one or more sports law classes. So what I strongly recommend is focus on another area of the law that really interests you. Again, for me, it was intellectual property. But there are so many different types of issues. There's a lot of family law related work. Athletes would be wise to get prenups. There's child support and child custody issues. Divorce is very common, and so on and so forth. Unfortunately, criminal lawyers can do very well in this area. Constantly, we hear about athletes getting into trouble in that realm, whether it's DUIs, domestic violence claims, or otherwise. You can get into intellectual property, obviously, as I have done. Estate planning is very important, and probate-related issues. You name it. So I don't think that anyone who wants to be in the realm of sports law should be hyper-focused on sports. Certainly, there are areas that are extremely specific to quote-unquote sports lawyers. For instance, I have 3 arbitration hearings before the end of this year in 2020, and they're all in the NFL Players Association. And the law there is very specific to precedent that has been established within that arbitration system. That is sports law, right? Like if we want to distinguish sports law from other areas, it would be those types of disputes. Mm-hmm. But by and large, a lot of the issues that we deal with athletes and agents and other businesses, it combines their personalities and the specifics of their situations with other areas of the law.
Well, and I think you're absolutely right. And to be more forthright on my end, when I was in undergrad, I was really looking into the sports law arena. I even attended a symposium at Northwestern's law school on it. Applied to Marquette in part because I was shocked they had Bud Selig teaching part of their sports law program. So I've always kind of had an interest in this area. And for example, when I went to that Northwestern Sports Law Symposium, it was very apparent that a lot of those people didn't plan necessarily to be in the sports law arena, but they, like you said, they did something different to brand themselves, and that just kind of created their avenue. Maybe they're doing labor law with the NBA Players Association, or they're doing some specific area of the law that kind of just was their gateway into the arena.
What I've found is a lot of general counsel at professional sports teams and a lot of lawyers at the players associations and the league offices were in private practice at large law firms. that previously provided legal services as outside counsel to those teams, to those players' associations, to those leagues. And by virtue of the relationships that they built vis-a-vis those types of engagements, and by way of them showing off their expertise, I believe is how they really got their foot in the door to go from outside counsel to in-house counsel. I think that's a very common path. It's very rare that you will start straight out of law school and go work in-house at a professional sports organization. It happens, but it's atypical. And when it occurs, unfortunately, or fortunately for those in this situation, it's often because they went to a top 5 law school like a Harvard or a Yale, and maybe the general counsel at that sports organization also went to that school, and that person had unique experience clerking for the program, for the organization while they were in law school. So I think it is very common, though, if you want to work in sport, that you put yourself in a position to work at one of these firms that may have relationships with the organizations, and perhaps you can build those relationships that way, not only at the firm that you work at, but at the sports organizations that you may want to pivot to eventually.
Do you think, as a quick follow-up, do you think that you have to be in a larger city in order to compete in this industry, or do you think that it's more readily available from people all across the country?
Well, answering that from personal experience, I don't think that it necessarily matters, especially in today's day and age. I think that you're able to brand yourself with all the tools that are available online, no matter where you are. I think to an extent it does matter where you're licensed to practice. For me, I do a lot of work with athletes who are based in Florida, with a lot of agents who are based in Florida. I have a good relationship, for instance, with the Miami Dolphins organization, and we work with a lot of players there. And certainly, if I was based in Idaho, I don't know that I'd have the same opportunity. And then, as I mentioned earlier, if in fact you want to pivot and work in-house at a professional organization, I think it does help to work in the same geographical jurisdiction as the organization where you may ultimately want to work at. And then finally, if you want to work at one of the larger firms, let's say a Proskauer, for instance, that does a lot of work with teams and sports leagues, then certainly you're limited in terms of where they're located. Despite the fact that they have a large reach, they're not in every location. So I do think to an extent it matters where you are, but less and less so based on how connected we are as a society through online. Unfortunately, there's no one bar exam you can take to be licensed in every jurisdiction. And for instance, in my state of Florida, we're very restricted. We don't allow people from outside the state to waive in. You actually have to take this bar exam. Whereas me being licensed in Florida, I can waive into many other jurisdictions. And I recently have in Washington, D.C., and I'm in the process of doing the same in New York.
That makes a lot of sense. The thing that seems to be a theme here is, from your perspective, what you're talking about seems to be, how do you brand yourself, right? And how do you get yourself into these particular areas? So transitioning a little bit here, you approach your legal practice from a different perspective, basically as an entrepreneur. So it's a little different than traditional law firms. Can you just kind of take a deeper dive into that for us on how Heitner Legal Services are different than traditional law firms?
Yeah, I think bottom line is I don't have a concern about being fired by an employer. So I don't have to worry about the content that I put out there. I just have to basically worry about appeasing myself. For instance, yesterday, I saw that a client that we've worked for, Fred VanVleet of the Raptors, signed a massive new contract. And here's a guy who came out of Wichita State, undrafted, continuously said, bet on yourself, believed in it, and it's paid off. And one of the things we've done is work for Fred VanVleet on the intellectual property side. And one of the tasks that we were asked to do is to register his design mark that he uses in his business to sell all types of apparel. And he's been doing that through his online website for quite some time. So I said, you know what? This is an opportunity to basically explore my my positivity, my happiness for Fred VanVleet, display that publicly, and also do a little bit of self-promotion. And really that's the hardest thing that I grapple with is how do I utilize social media to promote myself without it seeming like an advertisement. And one thing I don't do, I don't pay for advertising. So I sent out a tweet saying, I'm happy for Fred VanVleet. He bet on himself as a player and as a businessman. And I was happy that I was able to work with him to register his logo. And, that's a way that I'm able to basically continuously remind people about the services I provide and perhaps introduce new potential clients to what we've done before. And that's really how I've used social media to continuously build and grow the brand. But it is it's difficult to do it in a way that doesn't turn people off, right? I want to accomplish my goal of getting the word out without having people say, oh, there's Darren again promoting himself. And it's a challenge.
So I guess those discussions about players' logos and their intellectual property at the professional level seems pretty straightforward. But can you explain to people the ongoing discussions and issues within the NCAA regarding, the issue of name, image, and likeness?
How much time do we have?
As much as you want.
I'll be brief. I have long believed that every athlete deserves the right to exploit his or her name, image, and likeness, etc., publicity rights for commercial gain. And professional athletes have this right. College athletes have had this right taken away from them by the NCAA. So I've written about it extensively over the years. As you mentioned in the intro, for 6 years, I wrote for Forbes. I currently write for Above the Law and Sports Pro. I started a website called Sports Agent Blog back in 2005. And really on every medium, I have explained my position as to why college athletes deserve these rights. And ultimately, it caught an individual's attention last year in September, a representative who actually represents my district here in Florida. His chief legislative aide reached out to me, said he was interested in what I was writing about, and asked whether I would be part of the process to develop legislation in Florida with the intention of providing rights to college athletes. California had already passed such legislation, made it effective 2023, and we said, why wait so long? Let's hurry it up. Initially, we proposed July of 2020, so it would have been effective already. Ultimately, the bill passed with an effective date of July 1, 2021, and it was signed into law by Governor DeSantis. Right now, there are 5 states, including Florida, that have passed such legislation. We in Florida are the only that would be effective as of July 2021. Meanwhile, you have multiple efforts in Congress right now with proposals for creating similar rights on a national level. But nothing has really gotten past drafting any legislation or proposals. And it's rather unlikely that anything gets done before Florida's law is effective in July of 2021. Concurrently, you have the NCAA that's now changed its position and said, okay, we're willing to consider this. And very recently disseminated proposed legislation on the subject, which will be voted on by the Division I Council in January of 2021. So essentially where we sit is Florida, effective July 1, 2021, college athletes in the state having the ability to do endorsement deals, do autograph signings, make money off the field, off the court, et cetera. The NCAA may do something similar on a national level, and Congress could potentially pass something similar on the national level as well. But all we know right now for certain is that Florida will go effective in July of next year.
So what would the impact of states, or especially at the national level, what would the impact of these NIL laws be on the NCAA?
Well, it wouldn't really be an impact on the NCAA. It would be an impact on the individuals who will now have these rights back, which were taken away from them. And ultimately, it will allow athletes to earn more than what they're getting currently in the form of scholarships when they receive them, as well as cost of living. So really, what we're giving everybody is an opportunity. Not everyone will earn the same amount of money. In fact, we expect a non-revenue athlete to maybe have a capacity of a few $1,000s a year, whereas a starting quarterback at the University of Florida could make 7 figures a year from these rights. And so I don't know that it really has an effect on the NCAA. I think the NCAA's fear, or at least its stated fear for quite some time, was that giving athletes these rights would open up Pandora's box and it would essentially be the start of the end for amateurism. I don't believe that amateurism is a real thing. So I don't necessarily think that if that's true, it's a bad thing. The NCAA has said that they believe that this could cause athletes eventually being classified as employees and earning wages for the services they provide. Again, okay. It's not our intention currently, but if that is the ultimate effect, I don't necessarily think it's a bad thing. So we'll see.
I guess, well, to follow that up, though, if Florida passes an NIL law and then California passes a different NIL law, and you have a lot of states, this is just a common policy hiccup that happens throughout, various industries. But if they all have different regulations, how does the NCAA address that?
Well, it's not up for the NCAA to address. The state governments have the power over their constituents, and the NCAA cannot preempt state or federal law. So again, I don't think that it's necessarily the right question with regard to, what can the NCAA do about it? The answer really is nothing. The NCAA could potentially file lawsuits against those states that have passed such laws and say that there's a violation of what's referred to as the Dormant Commerce Clause, providing certain states benefits that others don't receive. I don't think that that is necessarily would be a strong argument for the NCAA to make. But more importantly, comparing California's law to Florida's law, there are nuances. Florida requires that athletes get financial literacy and life skills related education. I think that's a good thing. California currently does it. But the differences are so small. I don't think that there's really enough to be concerned about with regard to differentiation between the two laws and competitive advantage in one state over the other. Really, the biggest issue is Florida is going effective 2021, California is going effective 2023. But the way that you ameliorate this is, in my estimation, not the NCAA doing something about it, it's Congress on the federal level passing legislation that is reasonable, rational, and really probably mirrors what we've done in Florida.
So you're saying that you think it should be Congress's job rather than the NCAA, but I think it's a little bit harder to get a gauge of what Congress would do in that area. And honestly, they've got a lot on their plate. So when you're thinking about the NCAA, where do you think they are headed with this name, image, and likeness question? And where do you think they should go with the policy? I think that one I might know the answer to.
Well, I think that they're headed toward a vote in January with the Division I Council concerning this legislation, which may change before then. And I do think that it will pass. I believe that the NCAA will change its rules to allow a certain level of name, image, and likeness rights to college athletes. My concern is that it doesn't go far enough and that there's far too many restrictions on it. I recently wrote an article at Above the Law that covers 3 different areas of concern. And one big area that I'm concerned about is that the NCAA still doesn't want to give athletes the same rights that the universities will have, and essentially give the universities so much power that it's not an objective standard they will be using to decide whether or not an athlete can engage in a certain opportunity. I don't think it's fair for universities to enter into deals with alcohol beverage companies and sports gambling companies and say that the athletes cannot. Now, I don't necessarily take the position that the athletes should be able to enter into those types of deals, but if they shouldn't be able to, then neither should the universities. And then there's very overbroad and vague language with regard to the universities being able to prevent athletes from entering into deals if it goes against the school's values. And that type of language bothers me because I think that there really needs to be objective standards and as close to a free market economy for these athletes as possible, where unless there's something that is so outlandish and related to improper booster activity, these deals should just be going through, and there shouldn't be any stalling in terms of these deals between athletes and third parties becoming effective. I get the idea of having a third party clearinghouse in a sense, and I think that's wise for the NCAA not to be involved in that, but I still have my concerns.
Well, and you're talking about a policy that goes beyond the university canceling or preventing an athlete from taking a particular deal, not just if it conflicts with maybe an advertisement deal that the university have. So, you don't want an athlete to take a deal with Pepsi if the university is already with Coke. You're saying that the policy oftentimes will go beyond that.
I have a big issue with that. So if the University of Florida has a deal with Pepsi and it says that in a post-game conference, an athlete has to have a Gatorade on the table, great. But I can promise you that when the athlete is in his dorm, he does not have to be drinking Gatorade. And if he's drinking a Coke product, that's not a violation. There's no issue. So if an athlete wants to then have a deal with Coca-Cola, why shouldn't he be able to? If it doesn't violate the terms of the university's contract with Pepsi, why should there be a prohibition on the athlete entering into that deal? And then another problem that I have with the proposed legislation in the way that I read it, that being the NCAA's proposed legislation, is it seems to say that, let's say the University of Florida has a deal with Jordan Brand, that the athlete can't independently have a deal with Jordan Brand. So remember, when the athlete's on the field, he's wearing Jordan Brand uniform. But when he's in his dorm room or he's going to class, he can be wearing Adidas. Why can't the athlete also enter into a deal with Jordan Brand to always be wearing Jordan Brand? I'm not understanding the restrictions. To the extent that I am understanding it, it seems to be built in to protect the universities. And if that's true, then the NCAA is still doing a disservice to the athletes. This isn't true name, image, and likeness rights.
Well, is that not a tiered discussion that they need to have? So at least in my opinion, the policy of preventing students from engaging in deals where it goes against the university's policies versus a deal where it actually doesn't conflict, but may just advertise against something that the university has. So the Coke versus Pepsi dilemma, those are 2 different discussions that both probably need to be taken into consideration separately, correct? Or do those go hand in hand?
Yeah, well, we don't want disputes between the athletes and the universities. We don't want athletes to engage in contractual activity that will jeopardize the university's standing with third parties. So to the extent that a deal between an athlete and a third party would lead to a technical breach between an existing deal that was consummated by the university and a third party, yeah, absolutely, we want to make sure that we're preventing those types of entanglements. The issue is when there is no conflict, why should there be a restriction? And the way that I read the NCAA's draft of the proposed legislation, it seems as though the restrictions are going far beyond the worry about entanglements being brought up based on the athletes engaging with third parties. It appears to be more than that in the sense that it's really trying to shield these universities from having their partners leave those deals and just sign independently with the athletes. And that really shouldn't be much of a concern. My belief is these brands will find, as they do currently in the professional ranks, that there's more value when you associate with the program and the individual.
So changing gears a little bit, if let's say name, image, and likeness is for currently, amateur athletes is opened up nationwide, what do you think that impact would be on schools that have a good degree of notoriety, like your University of Louisville, University of Kentucky, University of Florida, versus like a smaller, more regional schools? What do you think that would do or mean for them?
I'm not sure. I think the people who cry out that it's going to create differences and an unfair playing field need to open up their eyes and wake up to the fact that there is a lot of disparity between those schools currently, and that if the University of Florida plays Vanderbilt, University of Florida is going to win 99 out of 100 times. And that's within the SEC itself. There's recruiting. What's that?
That's accurate. That's absolutely true. Right? That it's pretty funny.
That yesterday. Yeah. So there's disparity already. There's not a level playing field on the recruiting trail. Now, will that become larger? I don't know. I tend to think the answer is actually no. I think a lot of people, a lot of talented players may feel as though they can be the guy or the girl on campus at a smaller school, perhaps in a larger market, and have real opportunities. I mean, there are smaller schools that are in major markets that don't have the ability to recruit well currently just because they don't have a storied past. They don't have great facilities. They don't have big name coaches. But maybe that market that they're in opens new opportunities for them. So I really don't know. And it's sort of a wait and see. Will the rich get richer? Nobody has provided any sort of proof or evidence as to why that would be true. I think it's really just the people who were against this from day one who are trying to utilize that to justify their position. But who knows?
Do you not think that a place, such as Vanderbilt, that is in a blossoming city like Nashville could take on a much greater role because competitively, because they can recruit athletes and say, look, you have Nashville at your disposal to try and get deals versus going to a place even like University of Kentucky that's in Lexington, that's in a smaller market. Now they're more of a national brand, but they don't have the city of Nashville that can really produce a lot more economic development.
It could. I see the other way around, where it may not matter in terms of where the school is located. It may matter more about national exposure and how many games are nationally televised, how many are on ABC and Fox and ESPN as opposed to, a smaller network. There's a lot of variables here. Look at the landscape in the professional world and think about, to your point about location. So many players irrespective of the fact that the Giants and the Jets stink, would like to play there. It's a huge market. I think back to Le'Veon Bell, and I think like his big game plan of getting out of Pittsburgh and going to the Jets, albeit hindsight 2020, that was a failure. I think one of his big motivations was, I want to be in New York, marketable. I can make a lot of money off the field. And a lot of players think that way. So it's possible that we do see some change in the recruiting landscape based on geographic location and market size. It's all speculation until this thing gets started. And I think that's a really important point, which is there's a lot of activity going on in name, image, and likeness right now, but not until July 1 of 2021 is anything effective. So importantly, no college athletes can start exploiting their publicity rights currently.
So, Darren, I want to talk about, you mentioned you just don't agree with the term amateurism with regard to NCAA athletes. And I'd never really thought about that, but that to me is a really good argument. Like, I would consider myself an amateur in any sport that I play. But if I were to set foot on a Division I football field with other supposed amateurs, they would break me from head to toe. And it's so apparent that these athletes have an aptitude for the sports that they end up playing at a very young age. Do you ever see, in Europe, especially with soccer, we see like the academy programs and particularly athletic individuals being identified at a very young age and being allowed to transition into like a pro format much, much younger than in the United States. Do you ever see the United States transitioning into that kind of European style of sports management?
Where the athletes are sort of in these like lower level clubs that are owned by the professional organizations?
Yes. Yeah.
That's a really good question. I suppose anything is possible.
And obviously there's like, there's an infrastructure that would need to be built, and it's a big hurdle, but you look at how it's done over there and it's very interesting. And I think it's probably to the players' benefit.
You see 16-year-olds playing professionally
exactly
in Europe all the time.
And building just massive fan bases.
I think part of the reason why we haven't seen that is, at least our perspective, is that there's a differentiation between soccer and, let's say, professional American football, where, in terms of the style of play, the quote unquote violence or physicality, and I don't know the comfort level in America for creating those types of systems, at least with professional football. I'm not sure whether the distinction is proper, but I think that could be a big reason why we haven't seen it. I don't know. It's possible with basketball. I'm aware of, let's say, like an IMG Academies in Bradenton, Florida, where a lot of high-profile basketball players, tennis players, et cetera, go there at an early age prior to college and perfect their acumen, their skill. And so I think to a very lower level, that's what we see there, and we don't really see it replicated throughout the United States. More commonly, it's just the middle school to high school route with, in basketball, AAU and Pee Wee football and so on and so forth. But I suppose that you could potentially at some point see the European model bleed over to the U.S.
Fair enough. Well, so I would be remiss then if I didn't ask you, I think you've written about the topic previously. What is kind of your opinion as an outsider of the possibility of Louisville getting an NBA team at some point in the future, 10, 20, 30 years down the road even?
I think I wrote about that years and years ago for Forbes. Talked to a lot of very influential people in Louisville, including someone who became a very good friend of mine, Jonathan Blue. I don't know if you know him, but and he's done a lot in the agency world as well. There's always been a strong desire by those influential people in Louisville. I know that at one point in time, PricewaterhouseCoopers put together an analysis as to the viability of a basketball team in Louisville. And I know a lot has changed since then, and I'm not sure what type of analyses have taken place since then. But it appears that you'd have a very, very strong fan base that would support the team. But a concern has always been the market size and also the geography in terms of where Louisville is situated, which is really in close proximity to many other existing NBA teams. And then you also have the other issue of the NBA being very slow to have any expansion teams. The NBA is going through an extraordinary moment of growth, irrespective of COVID-19. And just look at the 44 players who have signed free agent deals for more than $1.1 billion thus far. But all that said, there's other locations that have argued very strongly for an expansion team. And so I don't know where Louisville ranks on that list. I know it's somewhere on there. I think the NBA has always looked at Louisville as a viable option, but I just don't know that it's number one or number two. And will the NBA actually expand to bring on more teams and more than one or two teams? And that's an important question. And I honestly just don't know the answer to it.
Well, that's completely fair. And I think the one argument Louisville tries to make potentially about market size is that you would have to probably include Lexington and then Cincinnati as well, because you have the share back and forth. There's a lot of Cincinnati Bengals fans and Cincinnati Reds fans in the city that go that way. You would think it would be reciprocal with basketball potentially. So, but that's really the only counter to market size and the close proximity to other cities, like Indianapolis and Memphis. But I appreciate the outsider opinion on this. Transitioning back a little bit more towards the leadership position. So you are currently on the Fort Lauderdale Board of Parks and Recreation and Beaches. Can you tell us a little bit what that's like and what you do on that board?
Sure. Well, I'm as I mentioned earlier, I have a degree in political science. I've always had a fascination with politics, which I know sounds crazy, especially with the world we live in currently and the political climate. But it's always interested me. I've always had this proclivity to be involved in civics. And so being involved with the process of the name, image, and likeness bill in the state of Florida and meeting some of the individuals that do work in Tallahassee, in their state capital, I became fascinated with getting involved in some form. And there were no races that I really wanted to run in 2020. And so when I was looking at the various types of local committees that I could become a part of, the Parks, Recreation, and Beaches Board particularly caught my interest. I'm somebody who has a lot of love for nature, outdoors, activity, the beaches, et cetera. And so, for me, it was a really good fit. And where I live, it's really important. Tourism is a big part of our economy. Outdoor activities are things that people here in Fort Lauderdale, Florida live for. I mean, whether it's paddleboarding, boating, going to the beach, exploring the parks, et cetera. So for me, it was a really good way to basically dip my toes in the water, become involved in some respect, and hopefully a starting point. I'm not sure what, if anything, I will run for in the future, but I am motivated to become more involved, and I think this is a really good start.
Well, that's awesome. So in your role, do you see, it seems like you're working a lot with like quality of life amenities that I've argued for a long time is extremely important in being competitive with other cities, whether it's like attracting or retaining jobs, but that also benefits the actual city itself, versus subsidies or other things like that. How important do you think those almost bucket list amenities are to cities that want to compete?
Huge. Fortunately, we have a pretty large budget to work on existing parks and actually create new parks in the city. But I think beautification is very important for every city. Having those types of parks for people to go to enjoy really improves quality of life, which then bleeds into many other areas, even outside of personal life, but also professional life and how well people operate in their business capacities. I think having these places to enjoy and appreciate nature and appreciate what we have and spend time with family, hopefully away from our cell phones, which we're always attached to, and I'm guilty of that as well, I think is really important. And it doesn't even, it's one of those things that really shouldn't have to be justified from an economic standpoint. I mentioned tourism before, but this is really about who we are as individuals and, having these places of peace and beauty and ability to kind of get away from the 24/7 life that we now live in, where we're just super connected and always attached to our phone and technology. Like having these parks and having the ability to engage in the outdoor activities, having beautiful beaches, which unfortunately are there's so much litter from tourists, but also people who live here. It's sad. I mean, we do beach cleanups and it's like the amount of plastics that are there, and we have endangered sea turtles on our beaches. It's really sad, but you feel good about going out there and cleaning the beaches and doing what we can to just make our world better. We're all affected by it.
So what do you think then cities, a city like Louisville without access to beaches that are obviously huge and attracting tourists can do to make itself more attractive from a quality of life amenities perspective?
Oh, I don't know specifically about Louisville, but my wife and I and our dog, we just took a 2-week trip to Utah, Montana, Idaho, and Wyoming. And we loved going out to the national parks and doing hikes and being in nature. And look, it was a time of COVID, and yet you had a lot of people out there enjoying what nature offered them in its natural environment. And so I don't know. I think maybe you can take certain things from those locations. Obviously, the geography and terrain lends itself to certain opportunities in those areas, but tourism was doing really well, especially in Utah. When we went to Zion, it was slammed, and we were talking to people. They said they've never seen tourism like it before. So maybe coronavirus, maybe a silver lining was that it provided an opportunity for people here in the U.S. to get out and explore all the beauty that actually we have domestically and do more activities out in nature, out at the parks that they never really thought about doing before. I know that's true for us.
Yeah, absolutely. I mean, I can sympathize. I've definitely been getting outside more often. You just get a little bit of cabin fever with everything going on with the pandemic. But before we wrap it up, we're definitely winding down here. I just want to give you a chance to promote any projects that you're working on or anything you're involved with.
Social media, you can find me at Darren Heitner. It's DarrenHeitner on Twitter, on LinkedIn, my name, Instagram, Facebook. I have a podcast called How to Play the Game. That's on Apple, Spotify, probably wherever you can find podcasts. And, that's pretty much it. I provide free information. I talk about sports business. I talk about sports law. I have a website, Sports Agent Blog, that's still around 15 years later, have awesome writers, also completely free. So check that out as well.
No, that's awesome, man. But before we let you go, we try and ask all our guests the same question at the end. If you had the power to change one policy for you, I guess it would be in Fort Lauderdale or cities across America. What would it be?
Ooh, in Fort Lauderdale. That's a good question. One policy that I would like to change. Are guests usually a little bit quicker to answer this question?
Fairly quick, but
Yeah, well, especially many of our guests are from Louisville, so maybe it's just easier to find things you want to change around here. I don't know.
The whole coronavirus pandemic has presented a lot of issues here, and sort of a lot of wavering as to whether things should completely shut down, should there be curfews, et cetera. I'd like to see some sort of policy that allows businesses to remain open and that we don't see a shutdown in the near future. But I am concerned that there are far too many people here in Fort Lauderdale who are going around not wearing masks whatsoever. And I'm mainly concerned for the elderly population in the sense that, we're coming up on Thanksgiving, the holidays, and I'd hate to see people as carriers spread it to the elderly population, because those are the individuals who are at risk. So it's not a specific policy change, but sort of a broad change where we respect the businesses, we allow them to stay open, but they need to be doing a better job of making sure that their patrons are wearing masks.
It's definitely a difficult balance to strike that I think most cities and states across the country have been dealing with. So the point is very well taken. But we appreciate you coming on our podcast today, Darren. This is fantastic.
Absolutely. Thanks for having me.
Yeah, thanks a lot, man. This is great.
We'll pick back up with our reaction segment after a word from our sponsor.
Well, Luke, that was another great interview. Darren was, I think, extremely interesting with, in particular, not just the NIL stuff, which I think we're probably going to focus most of this reaction segment on.
Yeah.
But, from my perspective, in undergrad, at least, I was very strongly considered going into sports law or sports agency, and I'm kind of glad I didn't. But it was a very intriguing interview from that perspective for me. What'd you think about it?
I loved getting to hear his insights on what it meant to be, or what it was like being a sports agent, what he saw as like the future of the NCAA's relationship with its athletes, and touching on his position in Fort Lauderdale at the end. That was kind of cool too.
And that was just the thing that you and I keep going back to over and over and over again is cities need to invest in the amenities to that really benefit their constituents, because then when businesses are looking for places to move or stay, they realize the happiness of their employees is one of the most important aspects. And I think he just reiterated that.
It can almost be like a chicken or an egg. Is it like the company's looking for that, or is it the employees? Like some people are looking at towns and then or look for towns first, and then they look for work, Yeah. Because they're just like, I need to live in Austin, or I want to live in Fort Lauderdale, and then they'll figure it out once they get there.
Yeah. Either case, the city should be building the amenities.
Yeah. No, for sure. But I don't want to change courses too drastically, but I kind of did want to jump into the white paper for this week. It was titled "The Olympic-Sized Loophole in California's Fair Pay to Play Act." And the Fair Pay to Play Act is the California law. It got all kinds of notoriety a year or so ago. It basically gave college athletes the ability to receive compensation for their name, image, and likeness. It's set to go into effect in 2023. So we haven't actually gotten to see what the results are going to look like in practice. But
well, and that's what Darren hit on, that Florida was going to come in 2021. Yeah. And so you might see the impact there before you see what happens in California, just because it starts earlier. But they are different laws.
They're different laws. And there's almost it's around a dozen states that have either voted on this legislation or are considering it, And so it's a really rapidly changing landscape in college sports. But the California law, I think, is probably what a lot of states are looking at when they're drafting their versions of this legislation. And the big hiccup in it from a policy perspective, it might not grant college athletes the share of compensation that many people expect, or at least that the media has maybe portrayed it to. So the issue here is that the athletes are actually required to, or the law contains a no conflict clause that prohibits athletes from, in the word of the law, they shall not enter into a contract providing compensation for the name, image, and likeness that is in conflict with any provision of the team's contracts.
So, for example, if the school has a deal with Under Armour, the athlete then can't go and sign with Nike.
Yeah.
And
or even if they do, they're not allowed to wear that on any team affiliated, school affiliated event, because those are all covered in the school's contracts and the team's contracts.
Well, and so, but see, I think that's the level of nuance that Darren was going into, right?
Yeah.
Is that, yeah, if University of Kentucky is a Nike school and all the athletes wear Nikes on the court when they're playing, but when they're going to and from class, that wouldn't necessarily conflict. I think it's going to be a delicate balance to ask student athletes to figure out what that line is, especially if they're not allowed to have agents or other people that can kind of guide them through it.
Well, the law actually does grant them the ability to hire an agent and a lawyer specifically to kind of guide them through this new name, image, and likeness issue. So the agent is to set them up with contracts. The lawyer obviously is to kind of keep them within the confines of the law. I think the issue from the athlete's perspective when you're talking about compensation is the schools brands aren't really paying them to walk around the school. That's not really the most valuable time for the advertising. It's when they're in front of, a TV audience, primetime television, like a major network game. You're going to be in front of tens of millions of people. And that's when brands want to see their logos on these athletes. And if that's going to be prohibited, then the value that they would derive from their name, image, and likeness is going to be substantially lower than if, they were allowed to wear whatever they wanted when
on the court. Yeah. But then you have I think that's still true for a lot of like the NBA stuff. There's the exception, if you're in the NBA and you're allowed to wear Nike shoes, I'm sure, KD can wear the KDs or LeBron can wear LeBrons, whatever. But it seems like in college, it's still going to be closer to if you want to make money, you probably have to go do the direct commercial, go do a used car sale.
Yeah, I was going to say, classic, a car lot sale.
To get most of the money. But this still brings me back to the issue that I think is the most potent, and that is that the NCAA is going to have to make its decision based on what all these other states do. Because if Florida doesn't have that conflict language, which I don't know if it does or not at this point, then how does the NCAA make its regulations if the NCAA's proposed language says that you can't conflict with what the school is doing, but the state of Florida does? So that means that the NCAA would have to make a very broad governing law or rule, or just not make any rule at all and just say that it's up to the states to make their own NIL.
Yeah, we've actually gotten kind of conflicting messages from the NCAA about how they're going to treat this. That they say that they're working towards their own provision to kind of provide clarity on how they think name, image, and likeness should be treated nationwide. But at the same time, some of the language they've used to talk about it might kind of indicate that they may be thinking about filing a kind of dormant commerce clause argument against, or a suit against, the current name, image, and likeness standards.
Which is what Darren hinted at, too.
Which is exactly. I mean, he definitely mentioned that. And like, we're seeing that, like, you're getting this kind of current patchwork of different legislations regarding name, image, and likeness. And when there isn't that standard rule, it's probably going to create winners and losers. And that would, essentially be what's going to give rise to that type of argument.
Yeah. And so it's going to be difficult to see the NCAA crafting a law that either wouldn't be prevented by the Dormant Commerce Clause or would be tight enough to encompass everything, all the states. It almost seems like it's impending for litigation.
Yeah. And I don't know how much you can trust just the current media framework to give detailed legal analysis on this topic, but I think the NCAA, you've heard a lot of people say that whatever proposed legislation they come out with to try and address this name, image, and likeness, it's going to fall far short of what we've seen the states try and do. That it's not going to provide the type of compensation that athletes would be guaranteed under the current framework in at least California.
Well, and is there anything that you've seen that the NCAA is planning on doing as far as going to have a shared NCAA image and allowing the NCAA to use the image of the student athletes?
I don't think they've actually indicated that anything that explicit yet. They've kept it pretty close to their chest, and I think that's probably how it's going to be until they actually come up with something.
Well, but see, this goes back to another kind of avenue that I think gets overlooked a little bit too. The thing that I take from personal experience is that, I played college tennis at the Division II level, not spectacularly high tennis, but I remember signing the NCAA form or the college form that the university NCAA got to use my image, for their type of promotions. I just wonder how that type of things, how that plays into all this NIL stuff going forward.
Yeah. It's tough to say. I don't know that we'll ever see the NCAA barred from using students' images. Like, I feel like that just doesn't seem like something that they're ever gonna.
But that's what happened with the EA Sports, with the NCAA college football a little bit. But that was more direct. That was using specifically those individuals, not like a group photo or like a group promotion of their university. It was more. Yeah,
and I think they kind of chose to head that one off the pass. They just discontinued the games rather than actually ponying up the cash.
Well, but there were lawsuits.
There were lawsuits.
That, so.
Specifically the one out of California for the UCLA player. Yeah. But I don't know. It's tough to say what they're going to do.
As a fan of the video game, I hope that they incorporate that into the name, image, likeness and pay all the players so that they can bring back some of those games.
Oh, yeah. Same here, man. I used to wear those discs out. But I think what we're seeing is a rising tide. Like, athletes are finding a voice, and they're definitely not shy about speaking their mind going into college, and especially professional athletes will still they have college players' backs that they think it's kind of unfair, and I think many just casual sports fans are kind of their ideas on the issue are kind of changing. And even the paper, it used the analogy of Olympic athletes up until 2019 were barred by the Olympic Charter from engaging in that same kind of no competition provision, by Rule 40 of the Olympic Charter, I believe. And what it did was it created a blackout period around the Olympics, basically bracketing them and saying that you're not allowed to sign any marketing deals that would conflict with Olympic events. Sponsors. Yeah. And so that same thing with the on-court appearances when you're at your most valuable. Like, for college athletes, it's like for Olympic athletes, the Olympics is like their time to shine. If there's a blackout period of a couple of months on either end, like, that's when you're at your most valuable. And so we saw that change at the international level. And I personally hope that we see a change for college athletes at the national level.
Yeah. Well, and I'll say this too. I think the NIL provides the balance between payment of players and not paying players at all. I do worry about the potential inequity if you allow for paying of players, that some schools just couldn't afford it at all, or some schools would pay players and their resources and their facilities would dwindle in comparison, and then it would just create a greater gap. But this NIL is very unique. I don't see, like Darren hinted at, we don't know where the value is going to be added, whether it's going to be the big, like Alabama football, Kentucky basketball, or if it's going to really help some of those other places like Vanderbilt, or even like a Butler University in the middle of Indianapolis that, their basketball team is popular. It's a big city. Maybe they get a lot more sponsorships. We don't know where this is headed. So I do think it's a good balance to help provide and still allow to have the equitability between all the schools, at least as much as the NCAA can have.
Yeah, no, I think it's a sweet spot, you know, and I really hope we get some kind of decision at the national level that does fairly compensate or allow for fair compensation of athletes
it was a compromise forced upon the NCAA. Let's not pretend like they were being proactive in this.
I mean, they've clawed tooth and nail to keep every dollar they can.
Yeah,
you know.
Yeah. But yeah, with that said, I think I don't want to beat this topic into the ground too much. I know Darren went a lot into it. So, is there anything else you have to add about this episode?
No, that's it for me, man.
All right, I'll just say, like, we decided to make this our maybe pre-holiday Thanksgiving episode and start the season a little bit earlier. So there's going to be a little bit of a longer gap before our next episode.
Yeah, just this episode, you know, with holidays going on and everything taking place, we decided to get this one out just because we had it ready.
Yeah, and make sure people have something they can do and if they're traveling or with a little more free time. So it'll probably be a couple of weeks before we start the rest of this season, but just stay tuned, guys. Appreciate you.
Yeah, absolutely. Thanks, guys.
As always, thanks for tuning in. Thanks for joining us on Building This Community. If you'd like any more information, you can follow us on Twitter at BuildingThisCom, COM, or you can follow Andrew
at Andrew J. Klump. And you can also follow Luke
at LMP43. Definitely subscribe, and we look forward to talking to you guys next week.